Hi, everyone. My name is Lake Shupek. I'm the North Carolina State Director for All on the Line.
And I'm Bree Bro. I'm the digital organizer with All on the Line, North Carolina. And we are here today to talk about the oral arguments that were heard this morning at the Supreme Court of North Carolina in the redistricting lawsuit. They were heard by the full Supreme Court, so 7 judges heard arguments from both the plaintiffs in the case and the legislative defendants. And I thought it was really interesting. I've never seen arguments before any Supreme Court before, actually. I've never watched that. And so I thought it was really interesting how, first of all, they only each side had got 45 minutes total for both their opening statement and answering questions and their rebuttal. And the judges just jumped right in with questions. And then, the lawyers had to answer the questions. And it seemed like they had, probably prepared some really great statements that they didn't even get to say all the way because they had to answer these questions.
Yeah. But I mean, they all were clearly very prepared.
Very prepared.
Did a great job. Were able to jump right back in. So
yeah. So let's jump into talking about first. Let's talk about what is the case about. Like, what are the plaintiffs asking the court to do here?
Yeah. So the plaintiffs are saying, first of all, we have expert evidence that these maps are extreme partisan gerrymanders. We believe that our state constitution has provisions in it like the Free Elections Clause, the Equal Protection Clause, the Freedom of Association Clause. We believe that those provisions prohibit this kind of extreme partisan gerrymandering. So they're asking the court to sort of agree with that legal reasoning and to overturn these maps for being extreme partisan gerrymanders that violate state constitution and create some kind of situation where you get alternative maps whether that's a special master being involved or a redraw or something like that.
Great. Okay. So that's what the plaintiffs are asking for. And then the defendants are, they have some arguments that they have some, the other side that they're arguing. One of those, let's just kind of go through those and talk about, what we heard today. One of the things that I heard that came up from the defendants was, they argue that the court can't address this partisan gerrymandering issue because the state constitution doesn't explicitly forbid it.
Yeah, and so, I think something that we heard from the plaintiffs and something that we also maybe heard from some of the justices was that courts do this all the time, right? So there's a really good example in North Carolina state law called this case called Stevenson. It's actually another redistricting case from 2000 where what the court did in part was take this part of the state constitution that says you have to keep counties whole when you're drawing districts. And obviously, counties don't all have the same number of people. And so doing that would be a violation of equal protection. I mean, of one person, one vote. Yeah. And so they they took the sentence about whole counties and created this whole legal regime where it's like, you look at these counties first and then these counties second and you pair these counties together and here's the formula by which you do it. And it's a very complex county grouping thing, never done in any other state before. No other state has this. It was kind of completely, a standard that was completely designed by the Supreme Court based on this one sentence. So complex that actually people now usually use an algorithm to figure out what the county groupings should or could be. And so that is what courts do. They look at the state constitution or other laws and they figure out how do you actually apply that in the real world? How do we think that you should apply that in the real world? So they, they create
what they're being asked to do.
Yeah, that's what they're being asked to do.
Okay, so another argument that's been brought up is that to do that, courts would have to create a standard. They would have to do sort of a similar idea of a thing as they did in Stevenson, where they'd have to create something new, a new standard. So that would be hard. That would be difficult to do. What is the response to that? What was the sort of plaintiff and response to the idea that they shouldn't do that because they'd have to create something new?
Yeah, well, I mean, going back to that Stevenson case, obviously they created a completely new standard there. And again, this is something I think we heard from, again, both the plaintiffs and some of the justices' questions. This is something that courts do. They create standards. I think it might have been Justice Earls who gave the example of, federal courts in the Voting Rights Act. So the Voting Rights Act was written, but there were many, many cases that took place that kind of put into effect standards around drawing minority opportunity districts where minorities would have the opportunity to elect candidates of their choice. And so it's a famous case called Jingles that where those standards were established. They were like, here's a 3-point test. Here are the things that you look at. Here are the things that you measure. Here are the things that you consider. And that's how you know whether you're appropriately, drawing this kind of district under the Voting Rights Act. So that is what courts do. They create standards in cases like this.
And in this case, the plaintiffs have offered a wealth of expert testimony and tools that could be used to kind of create that standard.
Yeah. There's been expert testimony from the plaintiffs' experts that does a wide range of different kind of analyses that the courts could, use. They could pick one of them. They could use all of them in totality. They have a lot to choose from in terms of setting a standard.
And another argument that was made was that by even doing that, the court would be legislating from the bench or usurping power of the legislature that's granted by the Constitution by doing something that would interfere with the legislative responsibility around redistricting.
Yeah, again, this is something that we heard from both plaintiffs and in some of the judges' questions. I mean, this, again, is something that the court does all the time. So for instance, if the legislature is the branch of our government that's given the power to write and pass laws, however, if the legislature passes a law that discriminates against a particular group in a way that violates our state constitution, it's the court's job to, analyze that and say whether or not that's happening and whether or not that law can be put in effect. And so, the court deciding whether or not something's unconstitutional doesn't necessarily conflict with the legislature's sort of constitutionally appointed duties, because the courts also have constitutional duty to do that.
They're a co-equal branch of government, aren't they?
Yeah, who knew?
Okay, and then the last thing that I heard in the arguments was this idea that we can't use all those expert testimonies and a lot of the analysis because that was based on statewide elections. And some of the districts that are in question here are local, like legislative districts, so more localized. And they didn't use local outcomes to analyze these, to do this analysis. So the argument is that, you can't know what the specific, issues are in a given election, that individuals might change their party affiliation or change their vote or vote for a different party or split their ticket. So how can we use statewide elections to determine whether districts are, like how a given district is going to perform and whether they're fair or not?
Yeah, so something the plaintiffs brought up, and I think something that if you were watching the trial, we heard from some of those experts, is that statewide elections are actually a better way to decide, to figure out and predict the performance of a particular district. So, instead of sort of like trying to incorporate all of those little particularities, what those experts seem to be saying they're trying to do is actually use statewide elections and use a bunch of them to kind of shake out all of those particularities so that you get a good baseline prediction of how certain districts are going to perform. And so really what the plaintiffs are saying is that, these experts who are people on top of their field, they're highly respected. Their work has been extensively peer-reviewed over years, if not decades. Those people have, and their field in general have come to a consensus that using statewide elections is the best way to predict the performance of districts. And so, if the experts are saying that, I'm inclined to believe them. It makes sense to me for people who have a passing knowledge of statistics, like that's how that works. And so that's what the plaintiffs were saying, is that statewide elections are actually a better way to predict outcomes than trying to use different kinds of elections. And it's something that's well established as doing that well in the field where these experts are operating.
Widespread expert consensus on this. Yeah. Okay. So can you just kind of, you're really good at synthesizing all this information. So can you kind of just summarize the kind of the overall takeaway that seems like the defendants are making here, the argument that they're making?
Yeah, really, it felt really like we're hearing, it's basically like a teenager who sort of skimmed one book of existentialist philosophy and is well, we can't really know anything about the world, and it's really hard and like time is a flat circle, so like you can't know things for sure, so you shouldn't do anything. I mean that
we can't do it perfectly. We
yeah,
shouldn't
like
do
it
it
really
at all.
felt like they were kind of saying that it's impossible to know the court. It's impossible for the court to do this right. They can't decide. They can't do anything, so they just shouldn't even touch it. You know, and that is like I feel like that's a weird thing to say to a court because the court's job is to take complex situations and make a decision about how to, you know, apply legal principles in the real world. That's their whole reason for existing is to.
It's their job.
It's their job to look at really complex situations and say, people have to live in this world. How are we going to get this done?
Yeah.
And so, yeah, I think you know it was kind of a weird thing for them to be coming from that place when they're sitting in front of a bunch of justices who make those kinds of hard decisions every day.
Right. Yeah. Okay. Well, you know, courts can do hard things. They've got a hard question here, a hard thing to do, but we have faith that they will do a good job, and we expect a ruling pretty quickly.
Yeah.
We're under a pretty tight crunch here to have the primary elections in May and have candidate filing reopen on February 24th. So as soon as we get that ruling, we'll be back here to break it down and hope to see y'all soon.
All right. Bye, everyone. Thank you.